Changes to contract obligations. Rescission. Rescission of a contract serves to discharge duties under the contract. This occurs when parties agree to rescind their contract. Agreement to rescind is itself a new binding contract supported by consideration, except in an at-will employment situation. Limitations are mutual rescission may be made orally. Exception, writing is required if the contract to be rescinded is subject to the Statute of Frauds and/or UCC. Parties cannot rescind the contract if the rights of a third-party beneficiaries have vested. Unilateral rescission is when only one party wants to rescind the contract, usually only granted where there is a defense to contract, enforcement, or formation, mistake, misrepresentation, duress, lack of consideration. As distinguished from mutual rescission, whereby parties agree to rescind contract, unilateral rescission often occurs as a court-ordered remedy where there is a valid defense to contract, enforcement, or formation. At-will employment, agreement may be terminated by either party. Permanent employment is generally considered to be at will. Modification and novation. Modification occurs when parties change terms of the original contract. Novation is a new contract that substitutes a new party into the original contract. Modification, subsequent change to terms of contract. Parties agree to discharge original contract terms in favor of new terms. Does not discharge the entire original contract. Requirements are mutual assent of the parties, and consideration, generally found to be present because parties have limited rights under the original contract by the modification. Modern trend allows for modification if it is fair and due to circumstances unanticipated when contract was made. Under the UCC, no consideration required for a good faith modification. Modification must be in writing if it falls within the Statute of Frauds. Note, parole evidence is admissible to show subsequent modification. Novation. Parties agree to substitute a new party to perform benefits and assumes duties that belong to the original party of the contract. Requirements is 1, a previous valid contract. 2, all parties, including the new party or parties, agreed to a new contract. 3, the new contract extinguishes contract duties between original parties. And 4, a new valid contract and new valid and enforceable contract. The original party is excused from performance and no longer has any contract obligations or liabilities. In an accord and satisfaction, parties to an existing contract to accept different performances in satisfaction of the original existing obligation. Accord is a new agreement to accept an alternative performance in lieu of the original performance obligation. Consideration is generally required. Consideration of lesser value is okay if new consideration is either A, different from originally bargained for consideration, B, to be paid to a third party, or C, to resolve a good faith dispute concerning the original contract. Satisfaction is performance of the accord agreement. This discharges the original contract and the accord. Effect of breach. A party may sue under either the original obligation or the accord if there has been no satisfaction.